This webinar will actually be recorded and added to our YouTube channel. So you'll be able to reflect on the content again. So as I say, my name is Mike Foster, Commercial Director at Chapman Robinson Moore. I'd like to introduce Kellie Peters from Databasix, who is running the webinar today, and under the title of How Ready for GDPR is Your Business? Now, I won't steal too much of Kellie's thunder, but we're probably all aware now that the new regulation comes into effect on the 25th of May. We've been working with Kellie now since probably October time last year as our external consultants to make sure that we're ready. And I'm sure you're going to find during this webinar, not just in terms of theory, but the practical advice that we've enjoyed and what we've been able to, as I say, be able to apply the regulations in a more practical way than perhaps some of the things that you may be reading online or hearing on the grapevine. So without further ado, I'm going to hand over to Kellie to run the webinar. Like I say, please do place your questions in the chat box as we go. Kellie, over to you.
Good morning, everyone. Okay, so you're probably feeling potentially a little bit overwhelmed about all things GDPR at this moment in time. You may not know whether or not it applies to you or not, and you may be a little bit uncertain as to where your data is. So what I want to try and go through today is trying to give you a sense of what you need to be thinking about between now and the 25th of May, and what you need to be thinking beyond that, because it's not just a tick box exercise. So I can't guarantee you're going to be any less overwhelmed, but hopefully you'll realise it does apply to you and you'll have an idea of what you actually need to do. So why is data protection important? For me, it is integral to what you do in your business. You can lose trust and reputation of your staff, of your customers, if you don't properly protect an individual's privacy. There has been lots of stories in the press, and you would have seen things such as Facebook, TalkTalk, Carphone Warehouse, all of whom have had significant press about how poorly they've managed data protection. And you don't want to ever be in that position. So it's not just a tick box exercise. You will hold a lot more information than you possibly realise, because it is, with the digital world that we now live in, you're storing data in a variety of different places. And it also includes paper. So it's paper and electronic. And really, ultimately, what we should be thinking about is how we can prevent harm to those staff, clients that we hold the information for, and we want to make sure it doesn't get in to the wrong hands. So in my experience, it's in your best interest to treat your access to business data as a privilege, not a right. So really what I want to cover today is the fact that the data protection in this country has been around since in fact, it's been in this country since the 1980s. But the current act has been in place since 1998. And what I focus on today is about accountability. What do you need to do to demonstrate accountability? How then are you able to be transparent with your staff, with your clients, with your prospects, with your suppliers, and touch briefly on some of the individual rights that you need to be thinking about. So some of you may have started to hear on the radio or seen on a variety of social media platforms the Information Commissioner, who is responsible for managing the data protection regulations in this country, has started a massive campaign in February. She focused very much on small businesses to say, anyone with less than 10 staff, you may be thinking data protection doesn't apply to you. Well, in fact, it does. Doesn't matter if you are a one-man bookkeeper, you are a nail technician, a hairdresser even, an electrician, or a photographer. If you are collecting personal information about your clients, whether it be name, email address, you are having to adhere to the regulation. So obviously anyone that's bigger than 10 staff, for sure this regulation applies to you. Now, what has also happened in the last month is that the Information Commissioner has started to release a campaign that your data matters. So you may now start getting inquiries from your clients. If you have staff, your staff may start asking you questions, well, what are you doing about GDPR? So the reality is it does apply to you. It doesn't matter what size your business is. If you process any identifiable information about an individual, otherwise known as a data subject in data protection law, then this regulation is something that you should pay attention to. So as Mike said earlier, we are now less than a month away from the new regulation coming in to play. I have had a number of questions asked me in the last couple of months to say, Kelly, well, when's the transition phase? And the reality is that we have actually been in a transition phase for the last 23 months. In the UK, we adopted this regulation in April 2016. So most organisations have had 23 months to get their head around this. And I think it's fair to say, as with many legal changes in this country, most of us have left it a little bit to the last minute. So, who does it apply to? We're all established, everyone, I presume, that is on this call is established within the EU. So if you are in the European Union, this Act applies to you. If you buy goods and services from organisations that don't have a European Union office, so many web-based providers may actually be based in the US or Australia, for example, but they are processing data on EU residents, again, this regulation applies to them. So if anyone's turning around to you and saying, no, we don't need to worry about GDPR, I would argue that they absolutely do because they're processing data on EU residents. And in terms of monitoring behaviour, just think about the likes of Facebook, think about Strava, Fitbit kind of devices that we have. There are a lot of those devices out there. We're in a much more digital world than we have ever have been before. So again, the regulation applies. What is really key in the GDPR is that we've always defined controllers and processors in data protection, but there is more responsibilities on processors now for the purposes of data protection. So a controller is any organisation that collects personal data. They are determining what data needs to be collected, you're determining how you're going to use it, how you're going to store it, how long you're going to hold it for. You also will determine if you're going to share that information. So you may appoint a external bookkeeper or accountant or a firm that's going to run your payroll, for example, or a company that's going to destroy your hard drives and your paper. These organisations are processors, and processors have to be responsible for data protection. They can also be liable for any breaches. Therefore, they have to demonstrate to you as a controller what they are doing, how they are managing data, how are they adhering to data protection, so that if they do inadvertently or deliberately cause a data protection breach, they have to report that to you as their client, as well as potentially reporting it to the Information Commissioner if the breach is so significant that it impacts on financial and emotional distress of the individual. I already covered the fact that it's large or small businesses, but what I really want to mention is the fact that there's been far too much attention paid on the breaches in terms of the value that you could be charged. Yesterday, the Information Commissioner, a month before the regulation comes in, made a very clear statement that her focus is not to penalise the biggest companies with the maximum amount of fines come the 25th of May. She will find companies that are willfully negligent. So companies that continuously neglect their responsibilities under data protection will be given enforcement notices, of which could be a financial penalty. So maximum fines are 20 million euros or 4% of your global turnover. In 20 years, the Information Commissioner has never issued a maximum fine of £500,000. So I don't believe the massive fines are going to come the 26th. So really, I want you to ask yourself the question, who is responsible for data protection within your organisation? If it's just you, the answer is you are responsible for data protection. If you are in a slightly larger organisation, what are the different departments? Each department will collect different information on individuals, and they all have a role to play. So your human resources, your IT team, you may have a legal team, your senior management, and certainly staff and associates and contractors, or volunteers if you use volunteers. So the reality is everybody plays a role in data protection. However, some individuals will have a role in determining what data is collected and how it's going to be used. And these are the people that need to really form together a task force, as I like to call it. So data protection from an accountability perspective is a whole business approach. Everybody in the organisation that handles personal data has a role to play. One of the things I want you to think about is identifying the individuals within your organisation that really are going to support you with your data protection compliance program. You also really should be thinking about how you are then going to train your staff. So once you've got a handle on what you need to do, there will be a requirement for you to demonstrate that you have trained staff on data protection, their role and their responsibility. Because 9 times out of 10, most breaches are down to human error. So before I talk to you about some of the practical steps that you really should be focusing on, I really want you to understand that there are many principles within the General Data Protection Regulation. One that is pretty fundamental is the lawful, fair and transparent principle. So when you are determining that you're going to collect personal data, you absolutely have to determine, are you being fair? Is it fair for you to hold this information, to process this data? And then you need to be thinking, well, lawfully, what's allowing me to process this information? Do I have an actual legal condition that I can rely on to process this information? Because that then allows you to be transparent. Without being fair and without being lawful, can you genuinely be transparent? And the answer is probably no. So there are 6 conditions that you can adhere to when it comes to the data protection regulation. Now, it might sound silly what I'm about to say, but just because consent is at the top of the list does not mean it is the priority condition that you need to use. You really do need to think about the different purposes for what you're collecting the data for. That will then help you determine what is the most appropriate condition. And I've got some slides that will talk you through the different conditions and how they apply to you. So there are 6 when it comes to personal data. And just to recap, personal data is anything that identifies a living individual. So this can be a photo, this can be video, it can be job description, it can be application forms, CVs, DBS certificates, it can be interview notes, it can be client files that contain notes about the clients. So the list is quite significant. So it is about identifiable information, which in the digital world also includes things such as IP addresses, location data. So the 6 conditions are consent from the data subject. It's very objective. The individual is giving you their consent. It's a requirement as part of a contract that you have between you and the other party. You have a legal obligation to process certain information. I'm not going to cover today necessarily to protect the vital interests of a data subject because these are predominantly used in life and death situations and predominantly by medical departments. And I'm not going to cover necessarily for the performance of a task to be carried out in the public interest, such as running elections, making sure tax is paid, mostly because these are functions that are run out, so that are responsible from a government perspective. So most local authorities will be responsible for this condition. And then I'm going to talk about legitimate interest, because legitimate interest is currently being used as a catch-all where they can't use consent. So I'm going to give you some guidance on that. So one of the things you absolutely need to look at is where are you using consent in your organisation? The question you need to be asking yourself, is it the appropriate condition? So are you using consent? Is it appropriate? If you are using consent under the GDPR, what you need to be able to demonstrate is that it was freely given. So there was no pre-ticked boxes. It was very specific, so you're not being kind of for marketing materials, or you're being more vague. It has to be, would you like to receive information, for example, via SMS message on our upcoming events? It's very specific, very to the point. You need to inform people about how you're going to use that data. So you can't tell people you're going to use it for managing an attendance of an event when you're then going to actually sell the information and make a quick penny, because it's valuable data in terms of the email addresses. You have to ask for a clear affirmative action. So this is you asking someone to press a button to indicate yes, they consent, or they're completing a form on your website where they press the submit button, for example. Now you have to demonstrate that all individuals have given consent, and on the 25th of May, you need to make sure that it retrospectively is applied to all of your data where you're using consent. Now, if when you're looking at your data, you're not sure if you've got, or if you're able to tick those boxes, you will need to do a bit of an exercise in terms of gaining consent. Now, what I've seen an awful lot of recently is a lot of organisations sending out emails asking people to reconsent to marketing materials, to reconsent to hear information about service offerings from clients. And what I want to make you aware of is that there is a separate regulation that monitors electronic communications in this country, and that is referred to as the Privacy and Electronic Communications Regulation. Now, if you communicate to individuals or sole traders or unincorporated organisations or partnerships, in the eyes of the law, in terms of the Privacy and Electronic Communications Regulation, they are referred to as business to consumer. Now, if you have a relationship in terms of you've done business with them previously, then you have what is referred to as a soft opt-in. If you have never met these individuals, they have never bought anything from you, then you do need consent. What you can't do is email them to ask them to reconsent for you to hold their information, because you never had consent in the first place. So they are actually breaching the Privacy Electronic Communications Regulation. Now, if your entire client base is business to business, so it's limited companies, it's incorporations, or it's PLC, then you don't need to worry about the Privacy Electronic Communications Regulation. You will then need to determine from a GDPR perspective, are you going to use consent or are you going to use legitimate interest? What you may want to consider is that some of your communications may actually be necessary for the performance of your contract. So, for example, I have a Mini. My Mini has to have an MOT every year, and the garage sends me a message, text me once a year, Kelly, your MOT is due. There are two types of contract. There is the pre-contractual relationship. So the example here I've given you is of a 30-day trial. So you may have seen, if you're ever going to buy an online product, they say that they'll give you a 14-day free trial, but you need to give your credit card details. And then they'll charge you if you forget to unsubscribe from it after day 14. So a precondition of that contract is your name, your email address, and your credit card details. If you don't submit that information, you won't get the free demo. Another example of a contract is that, for example, Amazon. Amazon cannot deliver a product to you without knowing a postal address. They will need an email address from you so they can confirm where to send the invoice for the confirmation of payment, and they'll need some kind of bank details so they can actually charge you for the product. So there are requirements in terms of contract. Now, contract obviously is not just the examples I've given here. You may have employment contracts, you may have contracts with clients, of which you state that as part of that contract, you will update them on the services that you provide or any changes to the contracts that you're running. Therefore, you'll send them an email about that. So is it a condition of you performing your duties under a contract? So I can hear a bit of background. So someone trying to dial into a... I apologise, there's a bit of background noise at the moment where I can hear someone trying to phone somebody. So I apologise for that. So the next legal obligation is, do you have a requirement under the law to actually report certain pieces of information? So, for example, under employment law, you have certain regulations where you have to adhere to where you are having to report certain information. So, for example, I've given here employee information salary. You need to be able to have that information. You need to do a PAYE return. There is certain information that you need to check from a right to work. So the Home Office require that you hold certain information and report that. You may need to do a DBS check to see if individuals can work in a particular environment. You may have to report information from the purposes of an accident happening on site. So there are legal obligations that you have to adhere to. So what you should be looking at is what data do you have that is a requirement of a legal obligation, and tell people about that. So apart from the fact that you've got consent, you've got performance of a contract, you've got performance because it's, so you've got an obligation because it's a legal requirement. You may also look to rely on what is referred to as a legitimate interest. Now, if you're going to rely on legitimate interest, it is in your best interest, for want of a better phrase, to conduct an assessment. And what you need to be assessing is, what's the purpose? Is it necessary? And is there a balance? Because as organisations, we're always going to have an interest in collecting information about individuals. What we need to make sure is that there is not an unfair balance in terms of what we want as an organisation versus what an individual may feel is potentially intrusive in terms of their privacy. So you need to assess the balance, you need to document your decisions, and then you need to tell people at the point of contact, say, for example, for a privacy notice, that you are using legitimate interest as the basis for collecting this right. Now, an individual, very much like consent, so an individual under consent has the right to withdraw that consent. Under legitimate interest, an individual can also ask you to remove their information from the system. So some examples of legitimate interest are, for example, an insurance company. I have a car, I buy car insurance every year. I'm very happy that my insurance company looks for fraudulent activity, because ultimately it's going to maintain or not too significantly increase my premiums every year. So my interest, I don't want premiums going up. The insurance company are going to undertake this assessment. All is good. I've got the example here of a suppression list. So if you are running a marketing list, what you'll have is everybody that's opted in, and then you'll have a list of people that don't want to be contacted. Now, you have to maintain a list of suppressed contacts so that you can demonstrate you are not contacting the people that have said no. And then the other example I've got is the ethical example of a refugee charity, where actually for humanitarian purposes, they're wishing to place refugees into homes. Obviously, it's in the interest of the refugee to be placed in a safe environment and to be able to share certain information with the charity. So what is the purpose of looking at your legal basis? What's the purpose of understanding if it's fair? Well, to be transparent, you need to be able to have a privacy policy, and you need to be able to know what you're collecting. So it's not enough just to tell people who you are, how to contact you. You need to tell people the purpose. So why are you collecting information on them? What's allowing you to process the information? You need to tell people who else you're sharing that data with. And you'll notice here that I've talked about how long data needs to be stored for. So we've always had a retention principle in data protection. In your privacy notices, you now need to tell people how long you're going to hold data for. So if it's from an example of an employee information, you're going to hold employee information for the lifetime that they are an employee of yours, and then up to 6 years after they've left. Tell people. Tell people if you're using consent as the method of and your legal condition, tell people how they can withdraw their consent. If you have to appoint a data protection officer because you're a public authority or you process large volumes of data for the purposes of monitoring activity, such as an insurance company or a bank, or you're an organisation that processes large-scale medical or sensitive information, special categories of data, then you have to, by law, appoint a data protection officer. Most of you won't fit that, but you will need to have somebody that is leading on data protection. You do need to tell people you're transferring data outside of the European Economic Area. A lot of you may use web-based systems. Have you ever asked the question, where is that data? And it's important because people have the right to know that their data is being transferred, and they have the right to ask you to not transfer that information. Which leads me nicely onto the fact that each data subject has a right. They have a number of rights under GDPR. These include the right to be forgotten, the right to portability, the right to information access. And if they feel that they, for any reason, that you are mishandling their information, they can raise a complaint. Or they can raise a complaint that you're not responding to a subject access request. And in your privacy notice, you have to tell people how they can complain. This allows you to show genuine transparency. So some of the things I really want you to take away from today, and one of the key exercises is mapping your data, because this is going to lead you to an awful lot of additional questions. So you'll have obviously the slides as part of the recording, but I want you to think about within your business, do you know what personal data you actually hold? So for example here, photographs, application forms, CVs, DBS certificates. List it all down. The best way to do this is on an A3 piece of paper, multiple pieces of paper in an office, and literally by individual types, so employees, clients, prospective clients, suppliers. Note all the different types of personal data that you're collecting. Then I want you to think about, do you process any personal sensitive information? So do you have to process anything on ethnicity? So do you report for equal opportunities perspective? Do you collect religion, medical records or biometric data? If so, why? Very importantly, where is the data? And this is where I think you may be a little bit surprised, because data is going to be in a number of places. It's going to be in Excel spreadsheets, on Word documents, on paper files, in filing cabinets, in individual desk drawers. It's also going to be in the cloud. But the question is, where in the cloud? Is it Sage, Xero, QuickBooks? Is it in something like Dropbox? Do you use any of the million CRM systems out there? So it's not enough just to name the system. Geographically, where in the world is that data? Who do you share the information with? So are you sharing it with bodies such as the HMRC, your pension provider? Do you share information with a data processor? So have you outsourced any of your work, for example, to an accountant, to a data shredding company, to a marketing firm? Note it down, because these are some of the things that are going to lead you to think about, well, do you have appropriate contracts in place between you and these bodies? You really then need to be thinking about which personal and special category of data are contained in what systems. So it is very likely that you are duplicating where your data is. So you may have it in a paper system, you may have it in an Excel spreadsheet, you may have it in a CRM system, you may also have it in an accounting system. So map it all out. Where's the links between the different systems? How is the information used? How is it shared? If these systems are all on your servers, then the data being transferred between systems is potentially protected in terms of encrypted. But if you're sharing data between multiple systems, how is the data being transferred? Very much talked about what's your data, how it's being used, really do take the time to think about lawfully what's allowing you to process that data, because you're not going to be able to complete your privacy notice in full without really understanding legally what's allowing you to process that information. And then once you've done that, and bear in mind that your A3 pieces of paper, you're going to have a lot of information on them, really then challenge yourself with the question of, well, how long can I hold this information for? Now, like I said, you may have legal obligations where the law is telling you what your minimum and maximum periods of time that you're collecting the data that should be stored for. Is your insurance provider telling you how long they expect you to hold certain data for? If there are no statutory requirements, what is a reasonable length? And that's the challenge you need to ask yourself. What is a reasonable length of time to be holding data for? Because any law firm will ask you that question. Legally, there's no requirement for you to hold this. What's the reasonable length of time? So, for example, if you have prospects on your system, what's a typical sales process from an individual coming a prospect and becoming a client? Is it 6 months? Is it 12 months? What is that cycle? So you could say, from the point I meet someone, I have their contact details. They are a prospective client. I'm going to hold their details on the system for up to 15 months. If they've not bought anything in that point in time, I will remove their information. You should also think about identifying the potential risks of a data protection breach in your organisation. And there are a number. This is not an exhaustive list by any shape or form, but we do need to be thinking about things such as how often has email been sent to the wrong person. So if you're using something like Outlook or Gmail, we've probably got the likes of being able to auto filter names and stuff. There was an example recently where an organisation up in the Midlands accidentally sent vulnerable information about children to a taxi firm, simply because they were typing in an email address and they didn't check to see if it was going to the right person. Do you allow staff to use their own devices? I was with a client on Monday and they quite proudly told me that they've got an app on their phone that allows them to log into their CCTV. So when an alarm goes off, because it's motion detected, they log into the CCTV app. The app is free. So I was like, okay, show me the privacy policy. So when we went to the app's privacy policy, it was all in Chinese. I was like, I've got no idea how secure this is. I've got no idea how they're using your information. So the same can be said for where your staff are using personal devices. Are they downloading, it's their phone, apps that could compromise information that on that phone relates to your organisation, such as emails? Do any of your staff take photos of identification on your phone because they don't have any other way of capturing that information, and then it's permanently stored on their phone because they've not got around to deleting it? Very common practice is post-it notes for passwords, or having a very weak password. So what is your process in terms of checking passwords? Do you force a password change every 90, 180 days? What's your guidance to staff on working from home or working on the move? How many of us have seen interviews being conducted in Costa Coffee or Starbucks, or we've seen people working on the train and there's no privacy screen? So actually you can look over their shoulder and see a whole wealth of information. So think about the risks in terms of where people do work from home. It's not to stop working from home, it's just risk assess that. Do you have a real risk of unencrypted devices? So if you're using a USB stick to take data from your office to your client, what happens if you lose it? There are obviously hacking and phishing scams that are constantly being on the increase. How many of you have secure websites? So if you've got a contact form on your website, have you purchased what is referred to as a secure socket layer certificate to protect the data from your website to where it's going? Google now ranks you on that, sure. Think about inappropriate user permissions. So if you allow everybody to have full access to everything in the system, yes, it's about trusting your staff, but there is always a temptation that if a disgruntled member of staff wants to access information, if you've given them full access, they will use and abuse that. which is the case of Morrison's. The very disgruntled member of staff downloaded information about all of 100,000 individuals' payroll information. He then posted that in the public domain. So really think about access controls. So again, when you're looking at doing your mapping, look about the potential risks that you've got within your business, and then build a plan about how you can reduce the risk and put in appropriate contingency measures. So really what I want to talk about now, because we've almost come to the end of my chat and allow you to ask some questions, is these are my recommendations in terms of what I really think that you need to start doing next. You really need to involve people. So if it's just you in the business, it is just you that needs to be involved. However, if you're working in an organisation with a couple more staff, who else needs to be involved in it? So think about your task force, think about who else needs to help you work towards implementing GDPR in your business. Really think about setting accountability. So to set accountability, you need to map your data flows. Who's going to be responsible? Who's taking the lead for data protection? If there was to be a data protection breach, who in your organisation is going to be notified? Map your data. I can't stress enough the importance of mapping your information. The Information Commissioner has got a lot of resources on the website where you can download tools that allow you to capture what data is being used, but first you need to map it. So where's your data? How's it being used? What purpose? How long are you storing the information for? Is it fair? Is it lawful? Determine your lawful basis. You will have to update some processes. So you'll have to update at least at a minimum your privacy policy online, because if you were to look at your current privacy policy, well, one, do you have a privacy policy online? Two, if you do, does it talk about the new individual rights? Does it talk about the fact that we now need to talk about retention? That then allows you to be genuinely transparent, but talk to people outside of the organisation. Tell people what you're doing to be GDPR compliant. And most importantly, engage people. It's not just going to be you within the business. You're going to have to speak to your data processors. You're going to have to talk to software suppliers. You are going to have to engage everybody in the organisation, because I've talked about the fact that they are a potential risk of causing a data protection breach. So if they don't know what data protection is, then they're more liable to do something accidentally. So really do engage everybody in the process. So we've got about 10 minutes, 10, 15 minutes, I think, for questions. So please use the chat box if you have any specific questions, which I can answer. So I'll give you a moment or two to type some questions in, and I'll hopefully answer them. Anyone else? So one question is about how would you handle the right to be forgotten, for example. So if a individual emails you and says, hi, company A, I want you to delete my data, would you know how to handle that type of request? So my answer to you is, do you have any kind of process in place at the moment? Do you have any... do you know where all the data is? Can you delete the data? Do you have, when you look at your lawful conditions, actually it's not based on consent, it's you have a legal obligation to hold information. For for example, an employee leaves the business next week and they say, can you delete all my data? Your answer would be no, I can't delete all your information because from an employment law perspective, I need to hold on to your data for up to 6 years. So it's about being confident that you can respond to questions. Another question I typically get is, where can I get resources to help me? I would absolutely recommend that you look at the Information Commissioner's website. She has a number of useful tools, so particularly look at the documentation section on her website, and that will give you advice about what should be in contracts. It will give you some advice about what a register should look like for personal data collection. Also, you might want to look at her privacy policy online. It'll give you an indication of just how granular it needs to be. So in terms of, so I've got a question here, is it compulsory for a small business with 5 employees to use software such as MyDocSafe? Entirely depends on what you're storing in MyDocSafe, to be perfectly honest. A lot of people use Dropbox, which is not the most secure system in the from storing personal data. So if you have 5 people, my question would be, what are you storing in MyDocSafe? My question would be, where in the world is MyDocSafe located? How are they demonstrating compliance with GDPR? And if for any reason they had a breach, how would they tell you? So what's the purpose of you using MyDocSafe? And then I would ask, like I said, I'd explore the purposes of where they're storing your information. So do a risk assessment on it, essentially. But I think it's a good question. So in terms of engaging people, the question is, CRM are our accountants. Is it necessary to contact them to ask if they are compliant, then store this information for future review? Absolutely. The answer is, where you are sharing your information with an organisation that's processing it on your behalf, you absolutely have a responsibility to contact those organisations, ask them what they are doing about GDPR. Hopefully the response will be, yes, we're compliant. It'll be, this is what we're doing. This is how we handle your data. Please refer to our privacy policy online. And this is what we are going to do to continue to be compliant. So identify all the other people that you're sharing information with and ask that set of questions. Are there any other questions that we have? Okay.
Okay, well, if there's no further questions, then I'll bring the webinar to a close. Just really with a thank you for Kellie for spending some time with us to share her expertise, experience and knowledge with us today. It's been invaluable to us as a practice. We obviously have read a lot of documentation before we engaged Kellie's support, and I think a lot of the information was contradictory at that initial time in October. There's a little bit more clarity now from the ICO, but what we have found, as I said earlier, Kellie, is a practical approach and how we can apply that specifically to our business. So I know Kellie hasn't revealed the last slide, but the last slide is her contact details. So if you feel that you'd like some support, I would say get in very early, because I know she's very booked up right up to the 25th of May. But there's Kellie's email address there, specific in their website address. So Kellie or her fellow directors can sure support you. And again, I'd reiterate the thanks to Kellie for her time today to share that information. This was our latest webinar. We have another webinar coming in May, which is an interview with Melanie Green. The details are on our website. As always, on our events section, you can see all our latest webinars. Later on in May, we've also got a webinar coming up with Free Agent, which is a piece of cloud software, which we're going to be showing you as a demonstration, and hopefully that'll be informative. If there are any other webinars that you'd like to see in terms of topics, then please do advise myself or your contact here at Chapman Robinson Moore. Leaves me to thank you for spending your time with us this morning, and again, hopefully it's put your mind at rest in terms of what perhaps some of the obligations are around GDPR, but also giving you an action plan and something practical to take away to start your implementation. So thank you again for your time, and enjoy the rest of your day. Bye for now.